SJC-13334.
Attorney Levin, I hate to interrupt you right off the bat, but if you are vindicated, your client's vindicated, is the result a remand, or is it that we enter that it should have entered?
So the answer to that is slightly different as to the two different classes of dispositions, but only slightly different, because my contention is that the proper disposition of the case is a reversal and a remand with a directive to allow the petition.
Okay.
In full. And I can address each of those individually as to this court's disposition, although it sort of short circuits the path
I wouldn't
of
skip the merits.
So I will come to that as to the slightly more complicated part of that answer. I'll come to that when I speak to the counts on which the petitioner was, on which the jury hung, and the counts were subsequently null pros. That's the slightly more complicated part. But I did want to address the counts on which he was found not guilty first, if I may. No party before the court this morning has argued that the first paragraph of Chapter 276, Section 100C implicates the First Amendment. And I think this court's analysis in Commonwealth versus Pond makes clear that it doesn't. And so given the absence of a controversy before the court on that issue, unless there are concerns, I would...
It's interesting, the court, Pond's is a deeply considered opinion. It wipes out the constitutional part, but it then leaves in place the ability not to automatically do it. So why did we do that?
Well, I can't, Your Honor, I can't speak to what Justice Cordy and the court subjectively, why they wanted to do that, but the first paragraph was not in front of the court in that case. Yeah. And so I think that's probably why, is that it just wasn't presented there.
Well, I guess my question is, didn't that footnote say the same standard should apply for paragraph 2 and paragraph 1?
Well, what the footnotes...
And so that the district court's resolution of treating both the same was all right, and given that Pond had changed the second, I think implicitly it was changing the first?
Well, so I agree with that in the sense that the footnote does make clear that the district court and the trial court should continue to apply the same standard under both paragraphs. And you're right, because the standard changes under the second paragraph, it necessarily also changed the standard under the first paragraph. But in terms of whether it was correct for the trial court to apply the same standard under both paragraphs, that's the issue that the court did not address in Pond. And that's the issue that's before the court this morning. And obviously my position is it's not correct because the language of the two paragraphs is quite different. And the language of the first paragraph of the statute renders sealing mandatory.
Just so I understand, Mr. Levin, so your point is, once we remove the constitutional prohibition, the statutory mandatory language automatically kicked in, even though we didn't say it should in the footnote. We invited you to come how many years later and tell us that it's well, weird yes. That we didn't do it. I don't know.
I mean, I agree. It was certainly was clear to me at the time in 2014 when I read that decision that the upshot of the decision was these not guilty cases now need to be automatically sealed. Okay. And I think the language of the statute is very clear as to that. The only gesture at an argument why the judge in this case might have been correct not to seal these not guilty counts that the Commonwealth has made here is they suggest that perhaps it would have been proper not to seal them because the petitioner was not acquitted on every count of this indictment. I would submit that you just can't square that with the language of the statute or the structure of the statutory scheme or frankly any other statutes that deal with this general topic. So you see in the first paragraph of Section 100C, what it says is, in any criminal case wherein the defendant has been found not guilty, the Commissioner of Probation shall seal said court appearance and disposition. And so that clearly refers back to the court appearances and dispositions relating to the not guilty. The not guilty is the disposition. And so, and then you have the second paragraph, in any criminal case where an nolle prosequi has been entered or a dismissal has been entered, and it appears to the court that substantial justice would best be served, the court shall direct the clerk to seal the records of the proceedings in his files. So what you have there is, if the Commonwealth is right that the first paragraph doesn't apply because there are disparate outcomes on the different counts of the case, well, in that case, then the first and second paragraphs both apply to this case, which also doesn't really make sense. And in fact, by the plain text of that statute, in any criminal case wherein a nolle prosequi has been entered or a dismissal has been entered by the court, if any case referred only to the entire case, then that paragraph would also apply to the entire case in a case where only some counts were dismissed and the defendant was convicted on some counts.
That doesn't, so if someone, forgive me if this is a silly question, but if someone was charged with 3 crimes and they were found guilty of count 1.
Yes.
Not guilty of count 2, not guilty of count 3. You're not arguing that it gets sealed because they were found not guilty of counts.
No, but I think that the upshot of the argument that the Commonwealth has made might suggest that result.
Because you have a blend in, you have not guilties and then mistrials, then not process.
Right, and so my contention is it seems clear to me that the statute treats each count individually. And if you look at Section 100A, which deals with sealing convictions, it's also clear that individual offenses are what they're looking at. And then also you can look to—
Yours is count specific.
Right.
Your analysis.
And you can look to Chapter 94C, Sections 34 and 44 of that chapter also deal with sealing certain convictions or non-convictions, respectively, of simple possession of drugs. And it's clear that those are offense-specific and count-specific, and that if one complaint comprised multiple counts and only one of them qualifies under one of those statutes, you seal the one count, you don't seal the rest of the complaint.
Yeah, I mean, you could have a client who's found not guilty of rape and guilty of assault, and you certainly want to get—
You'd like to seal that not guilty if you can,
rape,
and I think the statute makes clear that you can. And so at this point, I will move to the dismissed counts, if I may.
What's the standard? The standard of review of this is what? Because
abuse of discretion.
So it's an abuse of discretion. So he's referenced the different prongs of the analysis, right? So
well, he's set forth what the factors are that this court has laid out in Pond. Yes.
he's correctly set forth the factors. You've pointed out that he's got some timing issues incorrect.
He's made several factual errors that underlie his analysis, and I think totally undermine
See,
it.
to me, I don't find that that's what's driving. The difference between 3 years and 5 to me doesn't seem to be driving his analysis. What seems to me to be driving his analysis is he's worried that the reason it's null prost, one, it's a very serious crime.
Yes.
Mass rape, mass armed rape. And secondly, the victim can't, I'm not quite sure why she can't go forward, but she's not going forward either because of drug use or because she's frightened. I can't tell.
No, the representation from the Commonwealth, and I didn't actually, I think I didn't include it in the record appendix, but that it's also on the face of the nolle prosequi, that the reason is her drug and alcohol issues.
So, given that, and I'm trying to evaluate that in an abuse of discretion thing. I understand your points. The judge has made a couple of errors on how long, but this isn't 30 years versus 5 years. This is 3 versus 5 or 5 versus 7. To me, what's driving him is that it's a very serious crime, and you may be right, he's not the right person, but the victim can't go forward, and that's why this is null pros.
Well, Your Honor, I would contend that what you've just described is an abuse of discretion because it omits every other factor in the case. And
it doesn't. He applies all the other factors.
He doesn't, Your Honor. I mean, he says that he's considered all the other factors, but he doesn't discuss them at all. He doesn't discuss the severe stigma that attaches to these kinds of charges. He doesn't discuss the petitioner's age and complete lack of any prior criminal history. He looks to the...
I don't disagree with you, so now maybe you can answer my question. Is this a remand? And
No, Your
say-
Honor. And so, yes.
Go through these factors, Judge.
No, because my contention is, A, he's not making any credibility determinations here, or to the extent he is, he has credited the affidavit and the petitioner. So at that point, this court is in just as good a position as a single judge of the Superior Court to make a determination. But B, on this record, I would submit there is no other reasonable outcome besides ordering the records of this case to be sealed, that any other outcome falls outside the range of reasonable alternatives and would be an abuse of discretion. And so that's why I say that the proper disposition is simply for the court to remand with a directive that the petition be allowed. And I do want to, so in terms of the timeframes, what the judge says is that 3 years since the dismissals of the mistried counts is not a sufficient time to assess the likelihood of rehabilitation and the threat posed by the petitioner. Well, first, that's the wrong time frame. It's not just wrong as a matter of he got the dates wrong, which he did. It's also the wrong time frame to consider the time frame since the dismissals, as opposed to the amount of time since the petitioner has been out in the community not committing any crimes, which is 6 years. It's twice as long. And this court in Pond specifically says at page 317 that evidence of rehabilitation can begin from the date of the alleged offense and need not be limited to the date of the disposition, given the significant passage of time that can occur between these events. But secondly, the concept of rehabilitation does not neatly apply to a case where the petitioner has never been convicted of any crime. You can't hold against someone that they haven't presented evidence of rehabilitation when they're presumed innocent and they insist that they never did anything wrong. There's nothing to rehabilitate. And there's never been,
Then,
there's not even...
Don't you seal every case then? I'm confused by that.
Well,
If that's the analysis, why isn't there mandatory sealing of all the null pros? Did I misunderstand your argument there?
Well,
I understand
most...
he's presumed innocent.
Well, not every case will present in a situation where the person has no criminal history whatsoever, first of all. But secondly, this is a multi-factor analysis, and the judge didn't do a multi-factor analysis. But most importantly, what I'm saying is that this court's analysis in Pond is slightly off kilter here, because in Pond, that defendant had admitted to sufficient facts and gotten a quaff, and the case was eventually dismissed. This is, and had a lengthy criminal history prior to the charge at issue. And so this requirement of evidence of rehabilitation made sense in that context. It doesn't make sense to require someone to show that they're rehabilitated when there's no reason to think that they've done anything wrong in the first place.
What's the difference for this case, or in any effect? Is there a difference between a dismissal and a null pros?
Not in the statute, Your Honor.
No, not in the statute.
In terms of the balancing analysis, I think the reason for the dismissals clearly is an appropriate factor for the judge to consider. And what I suggest in my brief is that you want to place that dismissal along a spectrum from exoneration, which should require sealing, through to, say, a case that's dismissed because of the allowance
But when it's
of a
when
dispositive
there's a
suppression
null
motion.
pros entered, the government can bring the case back, can't it?
Yes, certainly.
But the reason for the null pros, under that reason, is also significant too, right?
Yes. And
Here, that cuts against you.
well, I think in some ways it cuts both ways, because it's a null pros after the Commonwealth had a chance to prove the case and failed to do it. And so
As far as the timing, because of the mistrial.
right, because he's been tried, he's not convicted, he's acquitted on some counts. Clearly, the jury did not fully credit the testimony that was in front of them, it seems. The judge entered required findings on some counts. But
Are the factors, the 6 factors in PON mandatory? I know they're not exhaustive, but You seem to be taking issue with the motion judge failure to consider some of these factors, suggesting that your position is that these 6 factors are mandatory,
It
even
is-
though, as you concede, some of them don't apply.
It is error to omit a factor where it is relevant. That is an abuse of discretion, to omit a significant factor in your
The
analysis.
statute is basically whether substantial justice, what the justice would be served. That's the standard. And Pond, as Justice Wendland points out, Pond gives us factors to consider that aren't exhaustive. So, I mean, I just hear you, and I think of the parole board cases where they're statutory, they're factors, and then we've said you should go through them all, even though you list them, it's not good enough, and that's what but because he listed the Pond factors, but you're saying what he did wasn't sufficient.
So it's
And I
one-
get if Justice Wendland's point to carry it forward is if they're not mandatory and he just focuses on one big one, is it still an abuse of discretion?
Well, yes, and so it's one thing to correctly state a legal standard, and it's a separate thing to correctly apply the legal standard. And the judge has done one but not the other here. And if you look through the LL case, which restated this Commonwealth's abuse of discretion standard of review, cites to Picciotto, which is a First Circuit case, which is fleshes it out a little more. And what they say is a failure to consider a significant factor or the erroneous consideration of a forbidden factor both constitute an abuse of discretion. And I think we have both of those here in the sense that he failed to consider these significant factors that I've mentioned and also erroneously considered this factor of rehabilitation when that's not a meaningful term for someone who's never been convicted of a crime. Thank you, Your Honors.
Thank you. Attorney Hanson.
Good morning, Your Honors. If it pleases the Court, Arne Hansen for the Commonwealth. I'd like to address the 6 Pond factors because I believe that the petitioner's petition fails on the merits. The impetus for this petition appears to have been the petitioner's desire to get a more higher-paying job. And the first factor laid out in Pond is the disadvantages, and it goes through several potential ones: unemployment, underemployment, community involvement. In this case, this petitioner seeks to address the underemployment issue. Prior to his arrest, he was a warehouse worker at the Christmas tree shop. In his affidavit and at the hearing, they failed to stipulate or failed to mention how much money he made in that role. After he was released and at the hearing, he was a truck driver. He failed to present any evidence as to how much money he made in that role. Judge Davis, who presided over the hearing, stated that it seems to have been an improvement over the job that he had prior to his arrest. And
Doesn't reference that in his decision, though, right?
Correct, but it was discussed at the hearing, and that.
Yeah, but we have to rely on what he writes, right, rather than what's discussed.
I appreciate that, but some of his reasoning is also displayed in his conversation with Attorney Tavares. They had a back and forth throughout the hearing, and it depicts that the judge did consider these factors, at least at the hearing. Attorney Tavares, who represented the petitioner at the hearing, also stated that the petitioner had applied for 4 separate jobs and had been declined in those positions. Those were a factory worker in Avon, a maintenance worker at Logan Airport, and then a driver for both Uber and Lyft. Again, the petitioner failed to identify how much money he would have potentially made and contrasted that with how much money he made currently as part of his position. So that leaves the court in a position of, is there really underemployment? Because we have no financials to actually base that decision on.
Can we really do that based on what the judge wrote, though? I mean, the judge doesn't, I mean, I get it. If you've got a rape, armed rape prosecution out there and on your record, that's, you can reasonably infer that's going to cut you out of some employment, right? I mean, the judge doesn't say that, but can't we just, we can assume that as easily as what you're doing, which is he hasn't applied for very much. I don't know. Don't we have to make the judge do that?
Yes, he didn't explicitly mention it in the decision, and as I stated, it was explored on the record and in the transcript during the hearing, which I believe should be part or could be part of the reasoning in this case.
This seems like what's driving this, I mean, again, maybe I'm overreading this, is this is a very serious crime, and the victim can't testify the second time, and the judge is nervous about wiping out that. That's, I mean, these other factors are kind of not really what this is. I mean, if I'm a judge, that's what I'm worried about. Is this guy not being re-prosecuted because we don't have a victim here? The jury, hung, and that's a worrisome thing for a judge to seal that record.
I completely agree with Your Honor. That would be factors 3 and 6 in the Pond decision, with the nature of the crime. Obviously, this is a horrific crime, and certainly there's a risk to the community, and the community has a right to know.
But Mr. Levin makes the countervailing point, which the judge also doesn't discuss, which is, hey, having that rape out there when he's never done anything ever in his life and they didn't convict him of it, that's the sort of Damocles over his head.
That is correct, and that is a counterbalancing argument within the nature of the crime portion of the Pond analysis. But again, the underlying issue is that he's saying because of this, he's unable to find gainful employment or employment that's going to pay him more money, but he's provided no evidence to that. All that he's pointed out is that he's applied for jobs that are similar.
But isn't Justice George's right? This is difficult. Don't we want the judge to go through all of this carefully and explain his reasoning to us? And isn't that the safest course on paragraph 2 for us?
That is certainly a fair analysis, Your Honor. I do believe that the argument does fail on the merits in the end.
But shouldn't we see it and have it all fleshed out for us? I mean, I understand why I wouldn't want to do it. And also, he's had a hearing, but again, can I shift you to paragraph 1 for a second?
Yes.
So, isn't Mr. Levin right? Once we remove the constitutional overlay, aren't we left with this mandatory language on acquittals that at least the acquittals should be sealed, or why not?
This case is a little bit messy in the sense that you have 6 charges. And some of them he was found not guilty. So on one rape charge, he was found not guilty. On the other rape charge, it was a hung jury, and the case ended up being null prost. With respect to the reason why it was null prost, the victim had a relapse as a result of testifying at trial. They tried to rehabilitate her numerous times, get her treatment. That didn't work. It took several years before the Commonwealth.
Is there a messy exception to the ceiling under 100C? I mean, it seems to be that's what you're arguing, that it's messy, and therefore you don't get paragraph 1 under not guilties.
The argument I would make there is the plain text of the statute, Your Honor.
Plain text is not for you, isn't it? I mean, the plain text says mandatory. Ye shall.
Correct.
Okay.
But it says cases. In cases where they were found not guilty, or there was no bill or no probable cause, then it shall be sealed. This was not a case where, as a whole, he was found not guilty. And that's why I use the colloquial term messy to represent this case, because it's not a case where he was found not
why
guilty.
wouldn't it just be Attorney Levin's formulation then? Then it's charge specific, count specific. Because if you really read it as strictly as you're saying we ought to, I think his argument has a lot of force. Then if you get 1 not guilty and you've got 6 other charges you were found guilty, then you're eligible to have that entire case sealed. That wouldn't make any sense. How is this any less or more messy than the ones you were found not guilty on, you can get sealed, and the others were still in play? Why isn't that just the right formulation?
I think that's a very fair point, Your Honor, and maybe this is something that this case can address.
Anything else?
No, thank you. I rest on my brief. Thank you.